we're here for final pretrial. Has there been any resolution?
No, unfortunately. Yes, there is, Your Honor. Yeah, unfortunately, I'm being reluctant because it's an as charged plea to the high back allegation. He does have a substance use assessment. If the court feels comfortable enough to proceed today, in light of your computer issues, we'd be happy to do that as well.
I think we're able to sentence today. I received the assessment back on March 9th and have reviewed it already. So Ms. Lawrence, is that accurate that he's going to plead to count 1 and dismiss count 2?
That's correct.
Mr. Vasquez, have you heard what the attorneys have said the resolution to this case is?
Yes, sir.
And is that how you wish to resolve it?
Yes.
All right. Well, there's also a ticket for a refused PBT. Does that have any bearing on the plea agreement?
We did not speak about the civil infraction crime.
Do you want some time to talk about the civil infraction?
One moment.
Sure.
Never gonna say that, right?
The people will dismiss the civil infraction.
We sincerely appreciate that accommodation. Thank you, Ms. Lawrence.
All right, so it's my understanding you're going to plead to count number 1 of operating with a high bodily alcohol content. That is a misdemeanor punishable by up to 180 days in jail and or a fine of $200 to $700 and or 360 hours of community service, rehabilitative programs, vehicle mobilization mandatory with a prior, reimbursements for the cost of prosecution and governmental expenses. In exchange for that, the people are going to dismiss count number 2 of operating while intoxicated. That is a 93-day misdemeanor. And they're also going to dismiss the civil infraction of refusing the PBT. Now, I want to make sure of a couple of things. One, have you had the adequate enough opportunity to discuss the plea agreement with Mr. Harrison and have your questions answered?
Yes, sir.
And do you also understand that if this case were to go to trial, you could not be tried on both counts 1 and 2? They would have to decide one over the other to take you to trial on. Do you understand that?
Yes, sir.
And did that have any bearing on your decision to enter into this plea today?
No, sir. No.
All right. Back on. Oh, will you raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Back on February 22nd, were you on probation or parole?
No, sir.
Were you on bond?
No, sir.
Do you remember reading and signing your advice of rights form, talking about your rights to an attorney and your rights to a trial?
Yes, sir. I do.
Did you understand those rights?
Yes, sir.
Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yes, sir. I understand.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plea today?
Yes, it is, sir.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
Nor am I.
All right. Then, sir, to the allegation that on or about February 22nd, 2026, while in the city of Cadillac in Wexford County, how do you plead to count number 1 of operating with a high bodily alcohol content?
Guilty, Your Honor.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on February 22nd, were you operating a motor vehicle in the city of Cadillac?
Yes, sir.
And you'd agree with me that that's in Wexford County?
Yes, sir.
And prior to operating that motor vehicle, had you consumed any alcohol?
Yes, sir. I did.
How much had you had to drink?
Quite a bit, sir.
What were you drinking? All right. Ms. Lawrence, are there chemical tests to support the plea?
There is, Your Honor. There was a blood draw done and that came back at a 0.288.
Mr. Harrison, do you stipulate to the results for purposes of the plea?
I do.
Do counsel believe the defendant's provided a factual basis in which to accept the plea and the court rule has been complied with?
Yes.
I agree.
The court agrees also, you find the plea is knowing, voluntary, and accurate. Sir, I find you guilty of operating with a high bodily alcohol content. I find that you were operating a motor vehicle in the city of Cadillac. You had consumed alcohol, and with a 0.288 blood result, that would be higher than the per se of a 0.08. So I do find you guilty of operating with a high BAC, along with anything greater than a 0.17 qualifies as the high bodily alcohol content. Pursuant to the plea agreement, the civil infraction and the operating while intoxicated will be dismissed at the time of sentencing, which I believe we can do today. I have seen the substance use assessment. Ms. Lawrence, have you as well?
Yes.
Mr. Harrison, do you have any additions or corrections to it?
I do not. I have a question about it that I think we can easily resolve. I did not see his self-reported incidents with, I think it was an MDOP and maybe a disorderly charge.
Yeah.
I did not see that on his lien, and I didn't know if that was something the court was in possession of, or perhaps they were juvenile offenses. He
So
does not recall.
I no longer have his lien in the file, but I do have notes about it. So I show in 08, there was a malicious destruction of a building, 200 to 1,000, 2 counts of that.
Okay.
There was an attempted CSC third in 13. In 17, an attempted SORA failed to comply. In 18, a domestic. And in 21, an attempted CSC assault with intent to commit.
Okay.
The assessment indicates that the BAC was a 0.226, but we're saying it's a 0.288, correct?
Yes.
All right. Any allocution, Mr. Harrison?
Well, indeed, this really presents a conundrum to me because as you look at things like we just talked about, criminal history, you can see the possibility that he's had issues with alcohol for a fairly long time. It would be reasonable to conclude that some of that prior behavior was as a result of his consumption of alcohol, or at least a contributing factor. On the other hand, I see a guy who's really focused on getting his act together, has been continuously employed since he was 9 years old, moved here from the great state of Texas for some reason as a young person, and attended high school in both McBain and Cadillac, and did graduate from high school. He's a hardworking guy. You can see he's not your run-of-the-mill defendant person, etc. You can see he has some other interests that give you a little bit of insight as to his personality. He enjoys writing poetry and music and dancing, and the first activity he put down as a hobby was running, which blew my mind. I can't imagine why anyone would do that as a hobby, but he does. Since I've known him, I've had contact with him. I've been impressed with his ability to be a stand-up guy, be forthright. When he first came in to talk to me about this case, he's like, yeah, everything in there is accurate. That's what happened. That's what I did. I just want to plead guilty. And I frankly talked him out of it for the first couple of court appearances because we wanted to check every aspect of the case. We wanted to examine the circumstances of the stop, the arrest, et cetera, et cetera, et cetera. We didn't find any anomaly in there, not one sufficient to raise a red flag that we could challenge it. And I have just been trying to prevail on the good graces of Miss Lawrence in the interim. I understand her position. It's a high BAC. There's some element of at least criminal history in the past. There is not a prior, obviously, drunk driving or anything like that. The problem is, and the real kicker for me here is that Jesus has to drive, needs to be transported elsewhere to continue his employment with the cement company, the concrete company. He's currently, I guess his status would be what, laid off? Pending the resolution of this? You're still working, okay. So I didn't know that. He does have the support. He has a partner that can transport him around and get around all of those issues. And I truly believe this was unintentional on his part. I truly believe he got caught up in the moment. They were out having a good time. We've talked about it a number of times. If he had it to do all over, he would have left that work truck and walked home. He's 4 minutes from the bar. So this was not something that I think was a product of him being emboldened or him being, in direct contravention of the law or him being stubborn or obstinate. I believe that it was a complete and total mistake on his part. Under the circumstances, it's easy to see how you could be caught up in the situation there. Now, that directive or that narrative is sort of swayed a little bit when you look at the high bodily alcohol content. Yet he was drinking wine for the predominance of the evening. We don't begin to understand that because even in all of his candor, he said that we're having a good time, we were drinking wine, but I didn't even cross my mind that I would be too intoxicated to drive. And that's partially because, as we've seen before, alcohol deflects your brain's ability to make an accurate assessment of your condition at that time. And secondarily, I hate to say it, but I will, it was only wine that he was consuming. I am also happy to talk to him about the kinds of things that are recommended in the assessment itself, such as counseling and highway safety and maybe acquiring some degree of skill or knowledge that could be imparted that would prevent him from making a silly decision like this in the future. The reason I wanted to lay that out for you is that came from him. He said to me, hey, I think I could benefit from this stuff anyway. I agree with the assessment. I think it's time for a reality check, et cetera, et cetera. So I'm impressed by his self-awareness. I'm impressed by his forthrightness. I'm impressed by the fact that he was willing to simply walk in here and say, look, Your Honor, here's what I did. I'm really sorry. I won't do it again. I was kind of sensitive to the fact that we pushed this all the way to a final pretrial on a DUI, okay? But that's where we are, and that partially is my doing. I think he could benefit from a period of probation, just as a reminder, on a semi-regular basis. I know the penalties for high beck, the fines, costs, suspension, et cetera, are what I believe to be unduly harsh, but that's the law. And he wants to continue working, obviously. So I think we've got a combination of things here. He's going to be working, so it doesn't really make any sense to put him in jail. He will be able to pay the assessments, perhaps on a payment plan, and he could benefit from a period of probation if for no other reason than he could obtain the counseling that he appears to have an independent interest in doing anyway. I would recommend that the court follow that course of action and place him on a brief period of probation despite the 180-day misdemeanor. Thank you.
Thank you. Mr. Harrison, I know the assessment said that his employment status was currently on hold pending resolution, but it sounds like that's not the case. So do we need to make that correction?
I would, yeah, that would be appropriate.
So you're still working?
Yes, sir.
All right. Were you at the time that they did the assessment, were you working then as well?
Yes, sir.
All right. Ms. Lawrence, any objection just making that correction?
Thank you, Your Honor.
Ms. Lawrence, any allocution?
Yes, thank you. There's a couple things that I find a little bit concerning here. He self-reports in his assessment that his 2 prior criminal sexual conducts involved alcohol. And now here we are several years later and he's at a 0.28, which is very high. I would say your average person probably wouldn't be functioning very well at a 0.28, let alone driving a vehicle. I do think that kind of speaks for itself there, that there may be an underlying issue here. He does test for alcohol use disorder mild. I think the high BAC is extremely concerning, as well as his prior criminal history that he self-reports involves alcohol. So I would ask for more of an extended period of probation in this case. I would ask the court to sentence to 24 months probation. He can get out early at 12 months if he does well. And I would also ask the court to sentence the victim impact panel as well as the alcohol highway safety class. Thank you.
Mr. Harrison made reference to this being a work truck. Was it a pickup, a commercial vehicle?
I think there was a misunderstanding there. It was my own vehicle. But I was driving like for work as a company vehicle, which is no longer happening, obviously.
Okay, but it was your personal
It was
vehicle.
okay.
Right. Okay.
I misrepresented that, and I apologize.
All right. Sir, you had the right to address the court prior to sentencing. Is there anything you'd like me to know?
Yes, sir. So prior to this, I had broken, I was close to 4 years sober. So it was last August, I had a company picnic, I decided to drink again. And I mean, a few months later, here. So I do understand how alcohol affects my life. He mentioned running, which is something more than a hobby, so I run ultra marathons.
Mr. Harrison and I don't, in case you couldn't tell.
So I found running to be an outlet instead of drinking, because at one point I did drink a lot. And fast forward to this, from last August, there's literally a handful of times that I drank, which doesn't change anything. I still made a poor decision to get behind the wheel, but I do understand what I did, and you know, I am employed. I do my own side work. You know, helpful, and then I do have a daughter, so you know, it was more than just causing being here, but it was also, you know, letting down people who are in the way.
So the 4 years of sobriety that you had before, did you do that on your own, or did you go through programming?
So I came home, and then no, I never did programming, so I just didn't do it.
Okay. So how much wine did you have to drink?
Your Honor, I do not.
Was it red wine you were drinking?
It was red wine.
Okay. Do you know what brought you to the attention of law enforcement?
I do not.
Ms.
I
Lawrence?
read the police report and said that I swerved out of the white line. So.
Okay.
You crossed the fog line a couple of times and touched the center line. Immediately, it was a longer narrative than that, but that was the decision.
So there's no accident, nothing?
No,
like that.
correct.
All right. So obviously your employment, I know you're still employed, but your job duties must have shifted a little bit.
Yes, sir, they did. So, like, the company vehicle, obviously, I can't drive. As far as duties, not really. I just can't drive the company vehicle. I still do have to, like, you know, it's concrete. So, you know, place attention.
So I know at the time of the arraignment, I wasn't the judge. I believe I was gone that day. But it looked like they gave you permission to travel to Indiana for work. So is that still an issue? Is that still something that?
I ended up not going through. That was it was side work.
Okay.
So I ended up not taking that or going.
All right. Is there anything else you want me to know?
Not at this time, sir.
All right. Well, Mr. Vasquez does present as a, necessarily want to say unique situation, but a situation that we don't normally see. And that is Give me just a second, because I don't remember something being in here. When you did your assessment, did they talk about your past use of alcohol and that you had the period of sobriety?
Yes.
Okay. Because that's not referenced in the assessment, and usually we see that. But that could explain why you're meeting the criteria for a mild disorder as opposed to something more. Because I have to agree with Ms. Lawrence, at a 0.288, most people aren't able to function, let alone drive however far it was. But the fact that you have the period of sobriety, there's times that that gets taken into account. And I see it different ways. Sometimes I see past severe, now active mild, for example. So that's probably taken into account without explaining in the assessment that it's been taken into account. So as I started to say, you're in the position that I don't see a whole lot. One is you've got the high BAC, you're testing mild, and you had an issue in the past that you've dealt with, and you had the lengthy period of sobriety. I see all those on separate things, but to throw them into one pot, I don't see that a whole lot. So given the high BAC, the fact that you had the period of sobriety, which bodes well in your favor, because you know what you need to do, you know how to do it, you've done it in the past. I am going to put you on a period of probation. And I'm going to do that. I am going to do the 24-month period. I believe that's appropriate given the level of intoxication we have. But as Mr. Harrison said, this is something that's eligible for early release. So if you do everything, or maybe it was Ms. Lawrence, sorry. If you do everything that we ask you to do at the halfway mark, you can be released at that point. So during the period of time that you're on probation, you're not to violate any law. Report is ordered, not to leave the state without permission, and to keep your employment and contact information current. You are eligible for the early release. I want you to attend the alcohol highway safety education class and victim impact panel, not to consume any alcohol, and you'll be tested pursuant to your probation officer.